said, which was they wanted to put me in segregation to keep me safe, right? Excuse me. And that's directly out of the Farmer versus Brennan standard, right? That the prison's duty is to keep every inmate safe. And intentionally disregarding a known risk to a prisoner is a violation of the Constitution because you are not intentionally keeping the prisoner safe. And this is where the dilemma lies with trans inmates, right? That if we put someone in segregation, we're punishing that person for being trans. We have a whole slew of documented medical, mental health, psychiatric, and case law that says that long-term solitary confinement is a violation of the Constitution, 8th Amendment. It also can be permanently damaging to someone's mental health. There was a lot of activism around this issue with the TAMS campaign to close the TAMS Supermax prison, which was our Supermax long-term isolation prison in Southern Illinois, which has since been closed. Thank you, TAMS campaign. For the similar reason, right? Long-term isolation, being in a room like that cell by yourself, even for a week or longer, we know that there are long-term permanently damaging effects to one's psyche. So how do we keep the person safe? This is a huge issue, and people ask questions like, should we have a transgender prison? Should we have a transgender jail? Should we have a wing of our jail that's transgender or gay specific? And that's kind of what we see happening in Cook County Jail, for example, in that Division 6 men's facility in the protective custody unit. Protective custody unit is kind of code for gay, trans, people who might be subject to sexual violence or physical attacks because of their gender identity or sexual orientation. And so we put them all together. They have limited access to things like dining hall, outside recreation, but they can walk around the cell and the wings of their unit freely. So they're not in isolation in their cell, and they have a cellmate. And so this is sort of the solution that some jails and some prisons have found for how to keep trans people safe. I think it's one of the moments where it's really important and helpful for us at TJLP to have an abolitionist lens on this work, right? That there is another option, which is that people don't have to be in prison, right? As opposed to building the trans prison, we have another option, which is no more trans people in prison. And I think we can do both at once, right? We can have some kind of temporary solutions to this very real and immediate need. I think not to do so would be really a violation of human rights and antithetical to trans rights movements in general, to just say abolition now, open the doors, that's our solution. I think that's part of our solution, right? And so having some programs, potentially the Cook County Jail program, although I'm hearing very mixed things about people being forced to live with other trans people or forced to be in this unit, that I can talk about more if folks are interested in that. But at the same time, it is a solution, and it's better, I think, than long-term isolation or, in some instances, the general population. I do want to say, though, that some inmates, some prisoners might prefer to be in the general population as opposed to anything else because actually they find protection from other inmates. That's something I really consistently hear, actually. And that the aggressor is oftentimes the correctional staff, not the other inmates. So in Dee Farmer's case, we have other inmates attacking her, but in most cases what we see is the correctional officers, the guards, attacking someone or permitting attacks by inmates, right? So kind of saying, yes, this is something we're going to allow in our facility and creating that type of culture. So that's one constitutional law issue, is the placement of prisoners and their safety. Now the deliberate indifference standard, that's the Farmer versus Brennan standard. Again, it is a U.S. Supreme Court case. Dee Farmer, trans woman, amazing. And that standard has been used in the treatment of prisoners as far as medical care. Okay? So deliberate indifference to a serious medical need is the standard that the court has interpreted the 8th Amendment to have for whether or not someone should receive medical care in prison. And I think it's important, I say this in every single training, just for us to wrap our heads around about the United States and what we do with criminalization and just our society in general, but that in prison or in jail is the only time that we have a constitutional right to health care. Okay, just let that marinate, right? The only time that the government has to provide us health care, according to the Constitution, is when we're incarcerated, because it's part of our punishment, right? It's part of our sentence. And the Eighth Amendment controls that and says that you cannot leave someone to squander, right? Someone cannot die on the floor of their cell of cancer and not have any treatment, right? That's actually cruel and unusual punishment. However, someone on the outside, right, who is in their home and is suffering, doesn't have health care, and all this debt is building up, right? We don't have the same type of constitutional protection around that. The ACA, again, is enacted by Congress, right? It's not the Constitution. So I think that's just important to remember as we think about this issue. And here in the Seventh Circuit, we have 3 cases that have all dealt with what the Eighth Amendment requires as far as treatment for gender dysphoria, gender identity disorder, or the mental health issue that is labeled for transgender people, right? The label we receive by, at least by the prison facilities. And I think this is an interesting moment just to think about, again, how activism and the legal system can work with each other or work against each other, because we have built a lot of case law around the validity of gender identity disorder and how it is a real thing and it requires treatment, and that's the way that we get courts to listen to us as trans people and to really authenticate our trans experience, right, and say, yes, this is actually a medical issue that needs to be treated. However, that's made it very difficult in a lot of other aspects, right? And we also have case law that says that you do not have the right to the diagnosis of your choosing, right? So if you are incarcerated, you've never been diagnosed with gender identity disorder, or maybe you go to a radical and affirming health clinic like the Chicago Women's Health Center or Howard Brown Health Center that doesn't do a GID diagnoses because they don't believe in GID, which is great, then you don't have the diagnosis that you need to require the type of treatment if you do become incarcerated. So it's a little bit messy there. So we have this case that says you don't have the right to the diagnosis or mental health treatment of your choosing, which is kind of the trigger that allows someone to have access to health care. But we do have a Seventh Circuit case here. The most recent case is the Fields versus Smith case. And this case came out of Wisconsin, again, in the Midwest. And Wisconsin did just a very tricky thing. And I'm from Wisconsin. I know that we love Wisconsin, but Wisconsin is making some interesting political decisions lately. And this is one of them, which is that the state passed an Inmate Sex Change Prevention Act. I feel like there needs to be an echo when I say that. Inmate Sex Change Prevention Act, which was a politically fueled movement when the public became aware that some transgender inmates were receiving hormone therapy. And just for the purposes of a brief Trans 101, transgender people might access a whole bunch of different types of medical care, or we might decide we don't want any types of medical care that are gender specific, right? So we've got transgender prisoners who want access to gender-affirming hormones, who feel that their body is already providing them gender-affirming hormones. We have transgender prisoners who might want access to surgeries, and there's not one type of magical surgery that changes us from Batman to Barbie overnight, unlike the kind of idea in maybe the legislature and some doctors' minds. A lot of trans people never elect genital surgeries. There's more than one type of genital surgery. There's a lot of other types of surgeries, facial surgeries, chest surgeries, hip surgeries, neck surgeries. You can remove hair, try to get hair to grow, do all sorts of things, right? And these are all considered trans-affirming health care. And I say that because in the Inmate Sex Change Prevention Act, the question is, what is a sex change according to Wisconsin? And Wisconsin described a sex change in the statute as hormone therapy, meaning the use of hormones to stimulate the development or alteration of a person's sexual characteristics, and sexual reassignment surgery, which means, according to the statute, surgical procedures to alter a person's physical appearance so that the person appears more like the opposite gender. So So again, that's still unclear to me about what surgeries they mean. However, what they did is they decided we're not going to provide hormone therapy anymore. No one was getting gender-affirming surgeries in the Wisconsin Department of Corrections, but this meant we're not going to provide hormone therapy anymore. And the reason why this is a great constitutional law case is because, unlike some of the cases that I've tried to work on and I'm currently litigating, where we're trying to get departments of corrections or medical providers within the departments of corrections to provide someone hormones who's never been on hormones before, in this instance, when this statute went into effect, prisoners who were receiving hormones were pulled from their hormones. Right? And that is a very different type of action on the part of the government. Right? It's one thing to say, I'm never going to give you this thing that you are asking for. It's another thing to say, I'm taking it away. And I'm taking it away basically overnight, which has a lot of physical, emotional, and really devastating effects for someone, especially when you think that that person is in isolation or is in a men's facility as a trans woman and is getting her hormones pulled from her that maybe she's been on for years. Right? So, the case was a constitutional challenge, and there were two challenges because of this government action. One was the 8th Amendment challenge, right? And that was the challenge that you have a constitutional right to health care, gender identity disorder is a serious medical need, and that refusing to treat someone for gender identity disorder through hormone therapy specifically is deliberate indifference to that serious medical need. That's the constitutional challenge under the 8th Amendment. But because the act is the Inmate Sex Change Prevention Act, which arguably only applies to transgender inmates, you also have a great equal protection challenge. And the equal protection clause is that clause in the 14th Amendment that essentially says you cannot take a classification of people, right? Create a class of people and intentionally treat that class of people differently than other classes, unless you have some legitimate state interest in doing that. And that's what the constitutional standard is, right? You cannot treat a group of people differently without a legitimate state interest. And we have some classes of people that we have more scrutiny for in government treatment, right? Like race-based categories are going to be suspect to a very strict type of scrutiny by the court if you're categorizing people on the basis of race and treating them differently. Right, but here we have transgender people. This is kind of the lowest level of scrutiny. But still, there needs to be a legitimate state interest in treating people differently. Do we treat people differently? Does the government treat us differently? Yes, it happens all the time, right? The Equal Protection Clause does not mean we cannot be treated differently or classified by the government. There has to be a legitimate purpose to do so. So the state of Wisconsin was called to court, and our allies at the ACLU and Lambda Legal litigated this case. I actually worked on it when I was a wayward law student at Lambda, which I was an intern in the New York office. I don't always tell people that, but it's true. So, when we worked on that case, we were trying to do a class certification, right, to do a class action lawsuit. There were a number of reasons why that didn't happen. But the case went forward with a couple of named plaintiffs. And the government, in a lawsuit, has to give its legitimate state interest, right? The reason why the statute is legitimate and why it's part of a government purpose. And they said that the reasons for limiting people's hormones were that they were very concerned about cost and they were concerned about security, other people's security, right? Other prisoners feeling uncomfortable with a woman in their men's unit, or that woman with her secondary sex characteristics developing will become subject to attack and violence, and the prison doesn't have any way of stopping that from happening, right? So denying her hormones is going to increase her security in the prison system. This was the idea. And in the district court opinion in Wisconsin, the court interpreted the Constitution and said on both counts, the 14th Amendment and the 8th Amendment count, this is unconstitutional, right? Unconstitutional. The government interest is bunk. It doesn't cost that much money to actually give someone hormone therapy. And in fact, treating the secondary effects of not giving someone hormone therapy, like depression, is much more expensive than just giving someone the hormones, right? So the financial argument doesn't make a lot of sense. When we get into the surgery question, the financial argument starts making more sense in the court's eyes. And then the second the second issue of the 14th Amendment question, equal protection, the court said this is just a grave violation. It's clear that the only reason why the statute has been passed is because of a disdain for transgender people, right? This is a legitimate type of health care. It's established by, decades of professionals. We have an international standard of care for this type of health care. Like, come on, we can't just say no. It would be like saying, no, we're just not going to treat diabetics, or no, we're just not going to treat cancer patients, just because it's too expensive, right? And so fortunately the court threw it out. The state of Wisconsin appealed. I'm not quite sure why, because they also lost at the 7th Circuit. And the 7th Circuit only ruled on the issue of the 8th Amendment. So for the purposes of precedent, which is really important in these court cases that interpret the Constitution, right, we need high-level precedent so that all the lower jurisdictions that fall under that court, so the 7th Circuit will be Indiana, Wisconsin, and Illinois, that we have precedent that we can use in other cases. So here our precedent, even though we had a great decision at the district court on that 14th Amendment challenge, our precedent is really just the 8th Amendment issue, which says for a prisoner who's been diagnosed with gender identity disorder, there is a right to treatment for that disorder, period. What the treatment is unclear. And as a trans person, even though this is a win for trans people, the language of the decision is a little bit disheartening, because being transgender is compared to having cancer and needing treatment for cancer, right? It's definitely a very pathologizing way of thinking about trans identity, and it's a very narrow kind of interpretation of gender and gender expression and trans people's desires. Also, it's been pretty hard to enforce the decision, at least in Illinois, because it's so vague about what the treatment needs to be, right? And as trans people, we don't just want to have, our hormone pill and then carry on with life, right? We need to have comprehensive health care. We need to have regular checkups. We need to know how those hormones are interacting with our cholesterol, with all sorts of things in our body, right, that could lead to other health conditions. And so it also doesn't require that you have, great health care or good health care. It just requires that you have to be treated for certain types of serious needs. And this is what the Constitution says. So that's our opinion. There have been a few cases that have come about with this hormone issue specifically. We've heard about the Chelsea Manning case. I'm sure many people have heard about that. Chelsea Manning coming out as trans and asking for treatment for her gender identity in the federal military context. And then we also have the Michelle Koslick case, which has gotten quite a bit of attention. She's a transgender woman in Massachusetts who first sued to get access to hormones and won in Massachusetts, and so she started receiving feminizing hormones. And then she sued again for sex reassignment surgery and for operations. And she won again in the district court federally, but the state of Massachusetts is appealing that decision. And so we don't have precedent yet. We don't have a decision on whether or not she will have the right to surgeries. But what we do know is that this is the first case ever that I know of in the United States where a prisoner has won the right to surgical care under the 8th Amendment, deliberate indifference standard. So why don't we, will you do that video? So we just have a little short video about what the importance of hormone treatment in Ophelia Delanta's case, and she won her case in court.
Our case against Virginia Department of Correction consists of failure to treat me and interfering with treatment that I was already getting.
Ophelia was intermittently on hormones until 1995. And then in 1995, the former director of the Virginia Department of Corrections, Dr. Smith, issued a memorandum in which he said, we don't do windows. People with GID are not getting treatment. There will be no treatment for GID. That's nuts. It's an established condition. It's in the DSM, the Diagnostic and Statistical Manual. There are experts in it. There's knowledge about it.
Michael Stokes, using the name Ophelia Delanta, filed a lawsuit on her own without a lawyer. and the Office of the Attorney General of Virginia asked that I get involved, or that this firm get involved, representing the medical defendants in the case. We filed a motion to dismiss. The judge, in essence, agreed that this was not constitutionally mandated treatment and threw the case out.
That fueled the issue of driving me to do something on my own. I felt that maybe if I could start it, then they would have to finish it. I wanted to get rid of my testicles, to stop the hormone, testosterone. At the same time, I feel that they're not supposed to be there anyway. And so that just led me to, at every opportunity that I could get, to cut.
When we first started handling this case in 2000, I went through all of the medical records that we had for Ophelia and pulled out each individual incident where she mutilated her own genitalia. February 22nd, 1996, self-mutilated scrotum with razor blade. May 21st, 1996, 5 lacerations to scrotum ranging 1/2 inch to 1 inch long. May 21st, 1996, later the same day, self-mutilated scrotum again, lacerations approximately 1/2 inch long. The list of incidents just goes on and on.
There are documented evidence of other personality problems going on with this inmate that strongly suggests that self-mutilation may be not so much a factor of gender identity disorder as simply manipulative behavior. I want what I want, and this is the way I'm going to get it. You had someone who was a difficult prisoner in a lot of respects outside of gender issues. It's not a foregone conclusion that treatment of gender identity disorder is going to stop the genital self-mutilation that was going on, or that the genital self-mutilation was caused by a lack of treatment.
From the standpoint that I'm operating at with regard to this lawsuit, it truly doesn't make a difference. If the state runs a mental institution for completely wacko inmates, they can't be permitted to mutilate themselves. They can't be permitted to hang themselves or to torture their other inmates. They can't. The Constitution still exists, and the Eighth Amendment still says that there will be no cruel and unusual punishment imposed.
What a transsexual goes through is, first, there's a sense of our identity, and that's the most important thing. And to have our body match what we feel inside, nothing else is important other than our identity. And it's like, if I can't be who I am, then I'd rather be dead than have to be imprisoned in a body that's not mine.
Okay. These videos are kind of heavy, and the topic is very heavy. The good news is that Ophelia and the litigants in the Fields case won their cases and have been treated, right? And Ophelia actually established precedent in Virginia for the treatment of transgender people in prison, which really means, interestingly, especially in some states that do not have discrimination protections in healthcare and other places, that prisoners might be getting more affirming healthcare by law than on the outside, than they were able to access on the outside of prison and jail. And again, I think this kind of brings us to the reason why it's important to talk about even things like litigation or remedies that we have in the legal system for violations of our constitutional rights in a larger framework, right, in kind of a larger movement sense. That Angela Davis actually writes about how we have to look at the problems that are happening inside of the prison as kind of an example of a microaggression of all the problems that are happening in our society itself. Right? There is a problem in our society that every single person doesn't have the right to gender-affirming health care. That's a problem, right? There's a problem in our society that folks are targeted because of their gender expression when they're walking down the street, coming home from the grocery store, or that someone has to engage in survival crime because they don't have the means or the economic or educational opportunities due to their racial background, their class background, their gender identity, etc. And so really addressing those problems as well is a part of helping transgender prisoners. It's a part of helping prisoners as a whole, right? Because it's not just trans prisoners that aren't getting the best health care. No prisoner is getting fantastic health care in prison. So with that said, these are the main constitutional law issues. As I mentioned before, if you're interested more in the actual process of litigating how these prisoners get to the U.S. Supreme Court, I can talk about that, but I think I want to open it up for question and answer. And I just want to say in honor, part of why I'm glad that I get to show this film here, that we have the multimedia to do that, is it's really important to bring the voices of the actual prisoners into the room, because I can't highlight enough how this area of law, the prisoner constitutional right area of law, is entirely driven by prisoners themselves. Right? These are folks who are litigating, who are going to court often without attorneys, working pro se. Maybe once they get into court and they pass their threshold level of whether or not they can sustain their case, get attorneys. But at first, it's really a self-motivated, incredibly brave moment of activism. And I think that really speaks to the resilience of trans people and the resilience of prisoners who are willing to fight and fight hard for the rights that they feel that they should have under the Constitution, and have really opened up this area of law for the rest of us. So I actually, even though the film is a little bit hard to swallow, I just am so inspired by Ophelia Delonta and others like her who have done this type of work on their own. So, with that said, do we have any questions? Yes.
Sorry, this may be terribly obvious question, and I apologize for it.
Oh, no.
But first of all, this sort of thing doesn't have a post-doctor for trans women. Would that be a fair statement, or maybe an unfair statement?
That's a great question. Sorry. The question was, does this sort of thing happen to post-operative transsexual women or trans prisoners? And I think what we can say by that is folks who have had genital surgeries, right? And there's two answers to the question. One is that I've never known that prisoner. And what I mean by that is that the types of trans folks who are incarcerated are not generally the types of trans folks who have had access to gender-affirming surgeries that are very expensive and not covered by health insurance. So I haven't seen that prisoner. However, what I can say is that the policy generally is to treat people according to the sex assigned at birth. If a prisoner had genital surgeries, other types of surgeries, all of their documents have been changed, their birth certificate, they were never arrested under their previous name or identity, so that their fingerprints, right, which we can't change, don't come back with other identifying information about their previous gender, or their sex assigned at birth, rather, that person may be able to slip through the cracks and be treated according to their gender identity. But I've never seen that to be true. Even in some instances where folks have had certain types of surgeries, like orchiectomy or breast augmentation, they have not been treated according to the gender assigned at birth, with two exceptions. I don't know if anybody saw in the Tribune, I think it was actually in the New York Times as well, when Tom Dart's office first released the new policy, the 2011 policy that establishes this magical fairy committee, the Gender Identity Committee at Cook County Jail that I was talking about earlier. There were 2 trans women who were placed in Division 17 in the trans women, that's a drug treatment facility for trans women at the jail. They were placed in a dormitory-style room, so that's probably about the size of this stage. It's built for about 50 prisoners, and they were in there by themselves, just the two women. It's physically in a women's facility, but still isolated as trans women. And one of them was interviewed by the New York Times. If you want to look, you can find it there. To my knowledge, no other trans women have been placed in women's facilities since. I think it was a bit of a media ploy when that policy was released. And I do want to give some credit, though, to Tom Dart's office, because it is one of the first policies that we've seen that really pushes what the status quo has been for jail treatment specifically. There are some prison policies that have come about, and those prison policies largely have come about because of prisoner-driven litigation that required that the Department of Corrections comply with a court order to create a policy to treat trans people. But this was a self-motivated policy by Tom Dart's office. It does cite to the Prison Rape Elimination Act, PREA. The Prison Rape Elimination Act is the first time that Congress has ever recognized that prison rape is a thing that happens, that non-consensual sex happens in prisons. It was passed under George Bush. And it's really quite an extensive piece of legislation that says, it really gives direction to departments to look for certain types of vulnerable populations who are statistically more likely to experience sexual violence. So that includes transgender people, it includes folks who are gay or lesbian, it includes folks with mental or physical disabilities who are often targets for sexual violence in prison, and not in prison, I would argue, and folks who are physically small are also targets. Basically anybody who's feminized, who's deemed as other, who's deemed as someone that's weak in some way is a target for violence. And so the jail policy cites to PREA, and I think it reflects an effort on the part of the Cook County Sheriff's Office to really try to put regulations to that piece of legislation to enforce its meaning.
Sorry, so one last part.
Yeah.
So if this person, this trans woman, actually finally gets access to a sex change operation, that person will then still remain in a male prison even though she has female characteristics, female genitalia? So she still remains there, she's stuck there.
Yes, it happens very frequently. Actually, one of the women in this film, she talks about how when she first was admitted to the prison facility, she was read as a woman. Nobody knew that she was trans. She appeared to be a woman. All of her identification said female. She identifies as a woman. Her name was feminine. And it wasn't until she went through processing that you were forced to strip search. You know, a lot of things happen in processing. And that's when the prison officials discovered that she was trans, and she was immediately taken from the women's facility to the men's facility.
We just had a story this week about what we think is the first Illinois case where they're providing hormones to a prisoner in an Elgin mental health facility. Are you aware of any other cases that? So that is the first time in Illinois that a facility is providing it. So, and this is it's in the mental health, but it's part of the correctional system.
Exactly. And all of my knowledge is based on you. But based on the Windy City Times article, yes, she was adjudicated to a mental health facility through the Department of Human Services because she was found unfit. No, she was not found unfit to stand trial, but she was adjudicated insane, which means you do not have the mental capacity to form the intent that's required for the crime, right? And the crime, based on the article, is triple murder count, right, of family members. And so if you do not have the mental capacity to form the intent to kill, you cannot be convicted of murder. However, that doesn't mean that you just get to leave and go home and have your married life. No, you are adjudicated to a mental institution, which is where she is. And so my understanding is that this is the first time ever that we've seen someone who's not actually incarcerated in prison or jail, although it is related to a punitive it's a punitive measure, is receiving hormones and surgeries, right?
Potentially, yeah.
Potentially, yeah. So yeah, follow the case. It's on the Windy City Times, on the online version. It's up right now. Yeah. Any other questions? Yes, Ms. Lutrobe.
Could you expand a little bit on the issue of pathologizing gender identity, gender identity dysphoria, etc.? I think everyone heard that. And because it's kind of a double-edged or multi-edged sword for the community.
Isn't it though? Okay, so the question was, can I get into more detail about pathologizing and the issue of gender identity disorder or gender dysphoria and the complicated relationship it has in our community and also just legal arguments in general. It makes me so frustrated. I just can't even tell you. No, not the question, just the thing, right? So we have, I think the first case that I saw that actually used the gender identity disorder model successfully was our cross-dressing case, the City of Chicago versus Wallace Wilson, which is our 1978 Illinois Supreme Court win that found that Chicago's cross-dressing statute was unconstitutional because we used to criminalize people for cross-dressing, which I would argue we still do, but it was actually a law on the books in our city, municipal ordinance. And these two transgender women were out to breakfast, having a lovely date, I'm sure, and they were arrested for cross-dressing, and they were strip searched. And the court acknowledges that they were found to have male genitalia, but goes into a great deal of description about what clothing they were wearing, including like the style of their hairdos and stuff. And they said that this was unconstitutional, and part of what they argued was that they were being treated for transsexualism. This was before GID was in the DSM, because it's 78. They said they were under the care of a doctor, and the doctor had told them that they had to live in their true gender, right? So it's all this very DSM-y language. They had to live in their true gender, and so they were doing that, and the doctor told them to do this, and the court said that based on that, and based on the fact that Illinois had just become the first state to have a way to change your gender marker on your birth certificate, because the Vital Records Act had been passed just the year before. It doesn't make sense that you can change your gender marker on your birth certificate but be criminalized for changing your gender performance in society. And it doesn't make sense that you can be criminalized for something that a doctor is telling you to do and is part of your treatment for this disorder. And it was a win, right? And we just see so many cases like that, where if someone can prove that they're a true transsexual and prove that they have GID and they've always thought that they were a woman from the time of birth, and they want all the surgeries, they've had all the surgeries, and therefore they are actually a woman, then in some cases the court agrees, but not even in all cases, right? You still get the cases where the court says, oh no, you're your chromosomes, or no surgeon can change what God does, and that's actually in a court opinion, so I'm not even, joking about that kind of language. And so I think it's been, a win in some ways. We do have, a lot of education that's happened at the judicial system that we know that trans people exist. But I think it's backfired because it's such a very narrow definition of what it means to be trans. The other tricky thing is that, trans people were all different and unique in our own ways. And some people really do feel that way. Like, they really do feel like they have been, the DSM narrative is 100% true for that person. And so they are going to make that argument in court that that's their experience as well. And so you don't want to take that away from someone either, right? Even though it is, of course, the argument that the court is going to agree with more if it does agree. So I don't really have an answer. I mean, I have used the argument that someone has GID several times in cases. It gives me an ouch in my stomach. But my client and I kind of think that we know, this is what we got to say. We know what we have to say. And actually, you do have this diagnosis, and it is a real thing, according to psychologists. So one thing that is a big question mark, I think, is, the DSM-5 has recently changed the definition of gender identity disorder to gender dysphoria. And so it's no longer a disorder, which means there isn't the requirement of dysfunction in your life. But it is still a mental health diagnosis that has a standard of care. And I think that's actually going to be tricky, too. I would rather they just remove the damn thing, because now it's going to be seen as less legitimized, I think, by court systems. In the Fields case, we have the comparison of being trans is like having cancer or like having diabetes, and there's a standard of care for treatment of these things. And when we have gender dysphoria, which has these different categories, and it offers a possibility that there could be a third gender or other genders, which is amazing in some respects, but the court is going to be like, what? We don't have a third gender on our, DMV issued state ID. This is strange. So I'm worried that that's going to backfire, but it's too soon to tell.